possible to get organized today.
Good afternoon, ladies and gentlemen, for another edition of the Motor Vehicle and Transportation Subcommittee. We've got 5 bills on the agenda today. Not all of them. Some of them are just discussion only, but let's just jump right into HB 178 from Delegate Guyton. This bill relates to parking and stopping in bus lanes. Bike lanes. We've talked about this for a week or two. I think we may have taken a week off and now it's back. My understanding, Maddie, you can keep scrolling. Just to remind everyone, what this really came down to is, let's see. There we go. Yeah. So just keep it there. This is really kind of the core thing here. So just to remind everyone, what this bill came down to is who do we provide exemptions to for this violation? One thing we have done with the amendments is we have made this subject to only a civil penalty. So if you can see there in line, I guess it's kind of like line 9 and 10 above 11, it said a driver or motor vehicle is subject to a civil penalty not exceeding $500. We removed any sort of criminal posture to this bill, so it's no longer a misdemeanor. And we have added the exemptions here, as you can see, for emergency vehicles, transit vehicles, vehicles picking up or discharging individuals with disabilities. And the one that was most controversial was this delivery truck one. And the sponsor has worked out a compromise with the Maryland Motor Truck Association, is my understanding, to allow delivery vehicles to park in bike lanes for a period of time, quote unquote, not exceeding 30 minutes. So that is the bill that's before us. Those are the amendments that are before us. So we'll start with Delegate Terrazzo. You're on mute.
Thank you, Mr. Chairman. I'm just trying to figure out, just I guess because we can't see the whole thing, like where was the criminal part taken out?
The violation was made a civil penalty in the 2 lines above line 11.
Right, but that's what changed, but then wasn't it a criminal penalty in the original?
Well, this makes it a civil.
Putting those lines makes it a civil.
Okay, did we take something out? I'm just like, because we don't have the amendment, do we?
It's on the screen.
Okay. Okay,
Got it. That's my question.
Yeah, I think by putting the civil penalty language in, I think that what Patrick is saying is that there was sort of a default presumption in the bill based on where it was written that it would be a misdemeanor, and by putting it saying that it's subject to a civil penalty, that I think it's now a civil penalty. Is that right, Patrick?
You didn't have to take any, sorry.
Well, yes, that is absolutely correct. In Title 27 of the vehicle law, it states explicitly that everything in this code is a misdemeanor unless it says otherwise.
There we go. Exactly. So sometimes I get things right. See, everyone, I'm not always wrong. Delegate Guyton.
Thank you so much for your work on here and getting all this put together, Mr. Chair and Patrick. I hate to throw a wrench into this, so hopefully this question won't. But I did hear from Baltimore Bikemore, I think earlier today, that they were concerned that the 30-minute for freight loading and unloading in this bill might supersede the Baltimore City regs, which they don't want that in Baltimore City. So is there any way we can exempt Baltimore City from that portion?
Here's what I would recommend. We'll see what Patrick thinks. I get the preemption concern. I would say that if there's will from the subcommittee to pass the bill, I think we just go ahead and do that today because we do have only 3 weeks left before crossover. And then I think if you want to put me in touch or Patrick in touch with the folks that you spoke to, I'm happy to chat with them about that concern. And if there is an amendment needed during full committee voting tomorrow, then I'm happy to offer one.
I think it's a great idea.
Thank you. That works for me.
Thank you both, Delegate Morgan and Delegate Guyton. Okay, do we have any other questions or concerns about this one?
Make a motion to move the bill with the amendments.
All right, so motion on the amendments first. Is there a second?
Second.
Move
all
the
those
bill.
Any discussion on the amendments? Seeing none, all in favor, raise your hand.
Aye.
Any opposed to the amendments? All right, a motion on the bill?
Move the bill.
Been moved and seconded. Any discussion? Final chance on the bill? Seeing none. All in favor, raise your hand. Any opposed? All right, that bill will receive a favorable recommendation from the subcommittee. Moving on to House Bill 219. I think, Patrick, correct me if I'm wrong, I think this one might still be kind of in the discussion mode, but this is Delegate Addison's bill regarding out-of-state plates. Patrick, you want to give everyone the current state of play?
Yes, okay. This amendment, and this is the actual amendment, it has two options in it. I'm actually growing to prefer option two. Option one is the one we discussed last week where we say for a first offense, person subject to the warning that requires them to, if they're an out-of-state vehicle, properly registered as a non-resident with a non-resident permit. If it's a new resident, then they have to get it properly registered. And then it puts on fines of $7 a day for 60 days if they don't do that. And for the record, Mr. Chair, you had suggested 45 days. I question and suggest 60 just to keep it
Uniformity.
yeah, uniform with the amount of time they have to change the registration over.
Yeah.
And Maddie, if you could scroll down a little bit, the second option is, you see the alternative language down here. What this does is it puts the violation against the vehicle, the vehicle, not the person. So by putting it against the vehicle, if they don't properly register or get the non-resident permit, then they still get the fines and everything, but then the local jurisdiction would get notified by MVA that, you know, they have not paid the fines or they have not gotten the proper registration, done the non-resident permit. And then the local jurisdiction would then be able to file an action in court civilly to get permission to tow the vehicle, impound it, boot it, whatever.
Right. And I just want to remind the committee how this differs from my understanding of how this differs in current law, which is basically that if you're operating in violation of the rules around when you have to have a Maryland licensed vehicle, right now the fine is $290, but there's no notice. Law enforcement has had difficulty enforcing this. If you guys have read the report since I sent it out a couple weeks ago, you'll see some case studies of how difficult this is to actually handle in real life. What we've done here, and we have two options here that Patrick has presented us, whether we charge it to the person or whether we put it on the vehicle itself, which lawyers call in rem, an in rem proceeding or an in rem action. So the difference here is that we're still eventually going to get to the ability of the car to be towed and impounded, like Delegate Addison wanted in the original bill. This turns the bill statewide. And it also says that before we get to that towing, impounding future, we do a couple of things. First, we provide notice to the driver so that they know, and so that if there's some situation where someone is just innocent mistake, you know, they've been a little bit too slow to register their vehicle, or it's a college student, or there's some sort of real reason, we give them notice and we give them 60 days so that they can contact MVA and get it straightened out before they are charged a single dollar. Then after that 60 days is over, they start getting fined. But it's a $7 fine per day instead of an automatic $290 fine. And we're hoping that the day-by-day fine structure, which we modeled after the insurance law, also provides them with continual notices before they're slapped with a huge fine, that if there is a legitimate reason for why they don't have a Maryland plate, they've got plenty of time before they're really hit with a severe penalty. However, because the fine continues for 60 days at $7, they actually can be fined up to $420. So in some ways, we're making the penalty more severe because we want to deter this behavior. But in a lot of ways, we're making this kinder because we want to make sure that if people are doing this legitimately, they know that there's a process they can undergo to get on the right side of the law. Delegate Terrazzo.
Thank you, Mr. Chairman. So if it becomes in rem, does that change the person's ability to get the car back, or how does that?
No.
Patrick? No. Okay.
So what, I guess, I don't know why we would choose one versus the other.
Yeah, walk them through the in rem thing again, Patrick, if you will.
Well, I think it gets us around the Fourth Amendment a little bit. We don't have to worry about having probable cause and things like that.
And I'm sorry, I'm not following this conversation. Like, the Fourth Amendment problem was what, and how does the in rem fix that?
Well, you can't just willy-nilly go around towing every car with a Virginia plate.
Okay.
And by attaching it, by giving the notice, by giving warnings, and maybe we should, ask the Attorney General for a letter of advice on this.
Uh,
But
Just to be clear, I'm not complaining. I'm just having trouble following the conversation, to be honest with you. But I think, I mean, I'm okay with the bill, and I don't have strong feelings about whether one is better than the other, because I don't really even understand why one would be, but
um,
I don't need to understand it much better than this, I don't think.
well,
Yeah.
and Maddie, if we could send this out to the subcommittee when this meeting's over so they can look it over, because this isn't for voting today.
Oh, okay.
Yeah, so I mean, basically,
Oh, that's helpful. Okay, then I
yeah, sorry, we're
definitely,
not voting this today. We just
okay,
wanted to give you
okay.
guys two options that I probably should have done a better job of explaining this, but yeah, I try to give you a little bit of flavor of how this bill came in, which was Baltimore City alone, going after the Virginia plate issue, being able to impound and tow vehicles. This has been Delegate Addison's crusade now, a very justified crusade for the last 2 years, because what we talked about and what is very clear in the report is that this is an escalating problem, not just in Baltimore City, but statewide. So we've turned this statewide, and essentially what Patrick has done is taken the report and generated two options. One is a penalty on a person. So in other words, the penalty would be assessed against a specific individual for violating the law. And we have notice and we have opportunities for that person to come into compliance. And we have escalating penalties on a day-to-day basis. The other option he's written, which is option 2, is an MREN proceeding, which means that anytime there's a penalty, you can either put it on the person or you can attach that penalty to a specific piece of property. Now, the person has to pay either way, but it provides you basically a little bit more legal grounding to tow, because now it's the vehicle that has the penalty attached to it. I hope that's helpful. Delegate Healy.
Yeah, I prefer that, having it attached to the vehicle. I think it's much clearer, especially if somebody's going to write a ticket. Parking enforcement can write the same, they could carry another packet of tickets with them when they go around, and they could just put a ticket on it, and that.
Yeah.
I mean, is that how it works? I'm sorry, maybe it's not.
Yeah. We could absolutely place, people could be notified either via their email address if it's with MVA, they could be notified via mail, and they could also be notified on the vehicle itself, which gets to the concern a little bit that was raised the last time we talked about this, is if you've got a college student, for example, who's, putting their car at someone's house, and their email, who knows, maybe it's like their college email they don't check very often. Well, if the car is parked on the street outside the family's house, then you would think that, after basically the 120 days that we've given them to figure it out, in one of those 120 days, they'd probably notice some tickets on the windshield.
Okay, I have another question, just a quick follow-up. Since you raised that, I mean, yeah, if it's on the public street, then obviously that's it. Does this also apply if it's sitting in somebody's driveway?
No.
Okay, thank you.
All right, great discussion. Appreciate Patrick's work on this as always. Please do take a look at the amendments. We'll absolutely send them around. Take another look at that report, and we'll try to take this up again next week. All right, we're going to move on to another repeat player bill, House Bill 234 from Delegate Stein. I'll again provide a little bit more of a context for you guys on what this bill does. Last session, Delegate Love put in a bill called the Sarah Lugenkamp Act, which was named after a resident of her district who sadly passed away, who was traveling in a bike lane and who was killed. That bill added a criminal penalty to this section of law dealing with vulnerable road users, but only for people who are in bike lanes. This bill from Delegate Stein expands that criminal penalty, the jail penalty, imprisonment penalty, to other types of vulnerable road users. So Maddie, if you can scroll down a little bit and you can get a flavor here of the different types of vulnerable road users here on the second page, you can see we're talking about.
Is it possible to make that a little bigger?
Yeah, absolutely. So we're talking about people who are lawfully either leading animals down a highway or lawfully operating or riding on shoulders, crosswalk, sidewalk. So we're not talking about someone who's jaywalking or someone who's riding a bicycle illegally. We're talking about someone who is seriously injured or killed, who is a vulnerable road user in one of these forms. And then, Maddie, if you can scroll down a little bit more. Here is the imprisonment penalty, which doesn't exceed 2 months. So this is what we're adding to this section of the code. And then if you can scroll down a little bit more. All right. So yeah, that's good. That's good. So a little bit, actually, you scroll up a little bit more. Sorry. Yeah. Okay. So this one thing that I think has created some confusion about this bill is the strict liability nature of the motor vehicle article itself, which does not require any mens rea component, which means that there's no intentionality, there's no recklessness that's required for motor vehicle penalties. However, that doesn't mean that you can violate provisions of the Motor Vehicle Act on accident or without any intent whatsoever. So if you look here on line 19, it makes it clear that you have, and this bill only applies to individuals convicted of a violation of Section B. And then if we scroll back up, can you scroll back up to B, Maddie? Yeah, sorry, back up. Keep going. Oh, sorry, yeah, there's B. I missed it. Sorry, back down. Okay, so B says an individual may not cause the serious physical injury or death of a vulnerable individual as a result of the individual operating a motor vehicle in violation of any provision of this title. Now, that's the part that I don't think I did a very good job of explaining when we last took up this bill. In violation of any provision of this title. Patrick, will you please explain to the subcommittee the import of those few lines and why I think it addresses the concerns that I've heard from a few of you as it relates to, for example, a car crashing into another car and that car then going into a sidewalk or into a crosswalk and hurting someone, and why we don't have to be worried about those kinds of accidental, inadvertent, or otherwise non-deliberate scenarios.
Well, yes, in that scenario, the car that was hit and then theoretically hit a vulnerable individual did not commit a violation of the Maryland vehicle law. They were hit, and the person behind them committed the violation. So that person would not be liable if they killed somebody because they did not commit a violation.
So Patrick, if someone is aggressively driving and they come into my lane and they don't actually strike me, but they come into my lane and they make me fearful they're about to hit me, and I therefore lean my car into a bike lane and I hit someone and I seriously injure them, would this imprisonment affect me in that scenario?
Well, I think you have to realize, I think everyone has to realize is that in motor vehicle law, any law, but motor vehicle especially, it's all fact specific on the situation. I would argue, I mean, if you're drunk at the time and you're not reacting.
Yeah, I'm not drunk, and I'm rationally trying to avoid a car coming into my lane.
Then I'd argue that you did not commit a violation, and I would take that to court if I was an attorney.
Okay, that's helpful. Thank you, Patrick. We'll now move on to questions and comments, first from Delegate Davis.
Thank you. Thank you. Patrick, it might be helpful to point out the violations, because I believe leaving the roadway is a violation.
If you're forced off?
There's no provision for being forced off. Leaving the roadway is a violation. Anyway, you guys, you know I don't like the bill. I'm going to vote against it. You can move forward as you like. I don't like us giving out jail time. It appears to be strict liability, and there's so many circumstances where people can get caught up in it. I don't like cutting out vulnerable people and even adding to it. Soon it's going to be everybody, even a dog. Anyway, I think it's duplicitous with the homicide statute. So that's what I have. I promised Vaughn I wouldn't belabor it. So that's all I have. Thank you.
Thank you, Delegate Davis. And one thing I will note that I spoke to Delegate Davis about is I do think it would be helpful, Patrick, to, now that this subcommittee has so many things that sort of intersect with the criminal law article, I do think it would be helpful, and I'm going to sort of take it upon myself to arrange this, but maybe have a work session in the interim where we meet with different groups and we meet with different experts, including Patrick, to kind of walk through the intersection of where, for example, reckless endangerment meets, for example, violation of the transportation article. But that's a topic for another day. Delegate Traza.
Thank you, Mr. Chairman. I share Delegate Davis's concerns about this, and it does go back to the strict liability piece. And I guess I just like to express my concern about us doing this versus judiciary, because I don't think, when she just brought up that point about leaving the roadway is a violation. And I don't know whether it's a violation in the same sense or not, but I know in Maryland, like if you hit the car in front of you, even if it's because of the car behind you hitting you, you're liable for that. So I don't know how that relates to the like this piece or not, but I'm really feeling uncomfortable with the strict liability and the jail time. And I mean, we could define it as not strictly liable, but Patrick, you were saying that like they take those things into consideration, but not necessarily if it's strict liability. I mean, that's the whole point of strict liability.
Yeah, on the force off the road, I'm going to take a look at the statute. I'm not sure about the liability if someone rear ends you and you rear end someone else. I just turn around and sue the guy behind me.
Right, but but this isn't just suing. This is now jail time. Like that's where it just really worries me, because we don't know what other types of violations there could be that might. I mean,
Yeah,
I
I mean,
really
if
do
someone
like.
hits you,
Well-
if someone hits you, Jen, sorry, Delegate Traza, sorry to interrupt you. If someone hits you and you hit another car, now civil liability is a separate issue. You have not committed a violation of the transportation article. That doesn't mean that you were not negligent and
Are you
could
sure
not
then?
could not be taken to court, but you would not be subject to a fine under this section.
And we
And then
know.
let me reread what the current statute, which is in the bill, says. An individual may not cause the serious physical injury or death of a vulnerable individual while in violation of the title. Now, if you were scared off the road, did you cause it and hit a bicyclist? If you were hit from behind and knocked into somebody, did you cause it? I would argue no.
But again, so, and I mean, I can, if everybody else is in a different place on this, that's fine, but I feel like we don't have enough information about that. You're saying you would argue that you didn't, but I don't know how that works, because we don't deal with the criminal code a lot. And so I'm quite nervous about, because if you hit somebody and then somebody else hits somebody, like, I don't know what assumptions are made under the law when that happens. And I don't know if that then is a violation of the code, unless it's a specific section and that's a section if you're saying it's only what's before us, but I don't think it is only what's before us. It's a violation of any other part of what violation of what part of the code?
Well, any part of the Maryland vehicle law.
When it says this title, it's talking about the transportation article.
So the whole transportation article,
The second and third part, yes.
the second and third part of it?
Yeah, the motor vehicle law.
Okay. Okay. I mean, I've said my piece.
Okay, appreciate it. Delegate Healy.
Thank you. I'm not an attorney. So I look at this from a different perspective. I'm fascinated by this discussion, but I want to focus on the other piece of what we're talking about here, and why although I'm very sympathetic to this whole issue of not adding jail time necessarily to everything that goes on, but this is about seriously injuring or killing someone. And we're talking about, what, 60 days at the most, if you've actually found guilty of doing that. It seems like that is not a disproportionate, over the top kind of penalty. So I'm kind of torn, but I really think that we're moving in the right direction here. I do want to hear from Patrick's research about where we stand if a innocent driver gets gets sideswiped by some other car going by, and knocks him into a vulnerable person on the side of the road, that doesn't seem right to me. That it seems like the person who hit them is the one that's
Yeah.
responsible, and therefore not the person who actually ended up becoming a missile, rather than deliberately driving in, and or even not deliberately, even accidentally, because they weren't paying attention or because of other circumstances where they're not driving the way they're supposed to.
Yep. Great. All right. Well, this has been a good discussion. Okay. Oh, yeah. I mean, I don't think we're in a position to vote on this anyway. Yeah. Delegate Zealer, are you okay? Yeah. I don't think we're in a position where we can vote on this today. Anyway, I think a lot of good points have been raised. I think it is definitely worth looking into this issue about, whether anyone has ever been cited for example, inadvertently or because someone else pressured you into hitting someone else and, then getting a violation under the motor vehicle title. And, Patrick and I will look into that over the next week, and we'll see if we can bring this back up for discussion. Delegate Jacobs.
Yeah, the only thing I want to ask, if you're involved in an accident where you're where there's death, you can be sentenced to jail currently, right?
Depends on, not if you're charged with this. And that's what happened in the Langenkamp case.
Right.
So
They were unable to charge the person criminally in the late.
there are avenues where you can escape the jail time, even though it's a death.
Correct.
Yeah, I have constituents that happened.
Delegate Davis.
I'm sorry, that's not true. Under the homicide statute, you can be charged with manslaughter by vehicle, right?
If you meet the elements.
Yeah, I mean, I think for manslaughter, I think you need reckless disregard for human life. And then obviously for homicide or, something greater, you need intentionality. But I think the issue is there a gap in the law between basically someone, for example, speeding, right? Someone's speeding, but not to the point where a judge would say they're recklessly disregarding human life. So if you're going 100 over, Delegate Davis, that could be manslaughter. And I think people have certainly been charged with manslaughter in cases where they're drinking and someone dies, because that drinking and driving is generally regarded as reckless disregard for human life. I think the gap here is for people that, for example, are going 20 over and they then hit someone in a crosswalk. Arguably, that's not a reckless disregard for human life. But in those situations, are we as a subcommittee comfortable with that person going to jail? And that's what we're trying to figure out. Delegate Truss.
Thank you, Mr. Chairman. So just in answer to that question, my answer to that, and I agree that it sounds like there might be a gap here that we want to be addressing, and I am very concerned about the lives, particularly of vulnerable adults, but individuals. But it seems to me that the question when somebody's going like 20 miles over is sort of a question. It's like a factual, it's a question. It's not like it shouldn't, again, it's the strict liability. It's that you either did it or you didn't part that. And it seems to me that there might be facts around that would tell us, like, we could up the ability to charge somebody with reckless endangerment or whatever, because there's a vulnerable adult. But again, this is strict liability. So what's that conversation look like in court? And can those other pieces of information be brought up, or will a judge say, I'm not allowed to consider those, either you did this or you didn't?
Right. So the judge would have to say that it is a violation of the statute, because if you are speeding, that's a violation of the title. And then if you did kill someone or seriously injure them, then boom, you have violated the title. There's no ifs, ands, or buts about it. However, the criminal penalty is still up to the judge's discretion, because Maddie, if you can scroll down, we're not saying that this is a mandatory minimum. We're saying that the person is subject to possible imprisonment not exceeding 2 months. So it's a maximum. It's not a minimum. So depending on the circumstances, the judge could fine them nothing, could sentence them to no jail time, could sentence them to a $5 fine, or could sentence them to maximum $2,000 plus 2 months in prison. And the circumstances that you're talking about was this person speeding because their pregnant wife was in the passenger seat? Was this person speeding because, they were going to be late to something it's extremely important? Or were they just speeding because they always speed?
Right. But they would be found guilty of this. It's
Not
just,
necessarily, because again, I mean, there's all sorts of prosecutorial discretion about whether or not someone's cited in the first place.
okay.
There's PBJs.
Right. So yeah, I mean, you're not necessarily found guilty of this just because it happened. And you're certainly not necessarily getting the 2 months. Delegate Ziegler.
Sorry. Thank you, Mr. Chair. So the other thing that makes me a little nervous is that there are really reckless bike riders who do crazy stuff on bikes, and I can certainly imagine somebody riding like on the very inner edge of the bike lane and, you know, coming out of nowhere and or slaloming or doing, you know, somehow being invisible to a driver. Because I have had that happen to me and almost hit somebody that I was just like, this would totally be your fault if I hit you, but
Well,
Yeah.
Delegate
Yeah, I mean,
Ziegler,
considered my fault.
Delegate Ziegler, I'd like to point out, Maddie, if you could go up towards the top a little more. Yeah, the definition of a vulnerable individual includes an individual who is lawfully operating or riding any of the following in a highway, shoulder, crosswalk, or sidewalk. Lawfully operating, and when you're operating a bicycle, lawful means you're as far to the right as possible.
What?
I'm just
Wait,
echo,
is that
oh,
law?
so it does? Okay.
Does it?
I did not realize that. Okay.
Wait, I don't know. You're saying that in our code, it says that they have to be as far to the right as possible?
Yes, bicycles do.
I was not
Where's
aware
that?
of that.
Where in the code is that? I'm just curious.
2112, Title 12, I believe.
Okay.
Subtitle 12.
Yeah,
I will
it's
say
true.
that law gets violated on a very regular basis where I live.
And
Yeah, it says bicyclists are required to ride as closely as practicable and safe to the right of the road.
Yep.
Yeah.
We don't.
Okay,
Yeah.
thank you.
But still point well taken, Delegate Ziegler, which is that, you know, there can be such scenarios here that are judgment calls and one, you know, he said, she said, and that kind of thing. So I totally get that. Okay. I think Delegate Davis's hand is stale now. So we're going to move on to, is that right, Delegate Davis, or did you have something outside? Okay. Okay. We're going to move on to the next bill. We'll do some homework in the meantime. This is Delegate Ziegler's HB 470, which we've talked about before. This is also for discussion only because we have not really finalized as a subcommittee the direction we want to go here. But as a reminder, what this bill does is it removes the intentionality component of violations of obstructing or modifying your vehicle plate. Right now, this offense, it requires someone to have done it intentionally. And there's been an open question and there's been discussion in this subcommittee about whether removing this intentionality language would make it easier for law enforcement to stop people. And so the reason this bill exists is because we've got a massive problem and an escalating problem in Maryland, but really nationwide, of what are called ghost plates, where you can easily purchase on Amazon some kind of film or plate cover over your license plate that makes it impossible for automated enforcement and for toll cameras to pick up your plate. And this is a big problem, both for just basic revenue of the state and making sure people pay for the roads they're using, but also in terms of people violating the laws. Now, the other element of this too that gets tricky that we have not discussed before is that these ghost plates also often prevent identification of cameras that are on, for example, stoplights that law enforcement sometimes uses to catch people after they leave like a murder scene. So, you know, I don't know if you guys have ever watched these true crime television shows before, but the modern way oftentimes that they catch people is they go back and they look at the footage that are on the cameras that are, for example, on stoplights, and they can track the vehicle as it moves from one place to another. Now they can use storefront cameras too, which oftentimes gives them the side view so they can see where the car is going, but they can't see the plate unless they have the stoplight camera usually. And if someone uses a ghost plate, then ta-da, now we can't catch the murderer. So that's what we're getting at here. And the question has basically become, as you can see here in the bill, is replacing this with intent to avoid with in a matter that may prevent. And so we've, you know, Patrick and I in the subcommittee have been kicking around a number of ideas. One thing I will note for the committee is that this dovetails into the conversation about what should be a primary and a secondary offense. which is a controversial topic and a conversation that the judiciary is also having. The other thing I'll note is that New York and other states that have taken on this ghost plate topic have also banned the sale of ghost plates in the state. And I think there's an open question about how that works with online retailers that we can look into, but also a number of states have done it. It probably can't hurt to ban the sale, even if it is sometimes difficult to enforce. The other thing too that we could look into that I've seen other states tackle is that sometimes if you go buy one of these on Amazon, the retailer will say that they guarantee legal compliance with the ghost plate, which is of course absurd because most states have in one way or another banned this, but the retailer is telling them that, oh yeah, you're safe, this is totally legal. Now, I think another route we could take here, in conjunction with the other ones perhaps, is making that some kind of unfair and deceptive practice explicitly to tell consumers who are purchasing these that they're going to be in legal compliance if they use them. So that's kind of the background, the panoply of things we're discussing. And Delegate Healy, I see your hand is raised. What I like to do now, though, if it's possible, is to kick it over to our friend Chief Morris, who I'm hoping will provide a little bit more context for us about why the bill is here, namely the extent to which law enforcement can or cannot enforce existing law. Is that okay, Delegate Healy?
Yeah, it sure is. I was just going to ask, can it be treated the same way as removing your license plate, not having one at all? Can it be like in that category of a thing? That's all.
Got it. That is an interesting, very interesting point, Delegate Healy. And maybe the chief has some thoughts on that as well. Chief Morris, you've been very patient with us. I really appreciate you hopping on this evening. Could you enlighten us on any and all topics that I did or did not mention?
Well, good evening, everyone, and I appreciate the opportunity to share some thoughts with you this evening. Delegate, I think you just about provided every bit of testimony that I could have ever provided. But I will say this: the specific language of the current law with the intent is a very, very high bar to meet from as far as issuing a traffic citation under Title 21 with regards to the rules of the road. So much so that I can quite frankly say that in 40 years and well over 10,000, conservatively speaking, 10,000 traffic stops that I've made, I've never issued a citation for this particular provision under Title 21 simply because of the way the language is written. And I could not conceivably go into a courtroom and testify that I knew what the intent of the driver was. They can simply say, I didn't know, it was decorative, whatever the case may be. I do want to say that this has very little to do with the rims that go around a tag. Whether it's the Commanders, the Chiefs, or the Philadelphia Eagles, or whoever.
Hopefully not those last two, officer.
whoever your choice of team might be, the Baltimore Orioles,
Or the
whatever.
Terps.
Or the Terps. There you go. Because quite frankly, those decorative pieces are designed not to obscure the tag or to block the tag or to prevent the automated enforcement from capturing the tag. And to your point, as it relates to the sale of these items, you're absolutely right. If you Google it, you'll come up with 100 different advertisements for devices to obscure your tags, or a spray that will blur your tag if captured on automated enforcement. So it is a challenge, and I know in my conversations with my colleagues in the Maryland Transportation Authority, it's particularly concerning as it relates to the tolls and things of that nature. Equally concerning to those of us that operate automated enforcement, and you're absolutely right, particularly the speed cameras just capture incidents once they've exceeded the 12 miles per hour and it's a still photo. But the automated enforcement on our school buses, the automated enforcement on our red light cameras, those are all video, and they're instrumental in helping us to be able to investigate criminal activity. So with that, the Maryland chiefs and the sheriffs, and looking at this law, and we appreciate Delegate Ziegler and Senator Kagan for bringing it forward. We just think that removing the intent piece will assist from a public safety perspective. I would say that we would support this whether it's as a secondary violation or the first offense being a warning. Almost all of your law enforcement agencies throughout the state now use e-tics. Those e-tics are interconnected. So if a warning is issued by a Prince George's County police officer today for having an obscured tag, and that vehicle were stopped 2 weeks later in Easton, and the officer ran the tag, it would pop up in the Easton officer's e-tics to show that the warning had already been written. So unlike the days of old when I first started and all your warnings were handwritten and there was no way to track a warning, we have the ability to track that now and ensure that motorists are given an opportunity to correct the violation, and those that would choose to continue to ignore it could receive a citation.
That's very helpful. Chief, I got two questions for you myself. So if I'm parked and you see me and I'm in a stoplight and you try to issue me a citation for this, would it be a defense to the intentionality for me to say that it's actually not my car, I didn't put it on there, and it's actually Delegate Addison's car?
Well, that's a fair question, Delegate. And the provisions under Title 13 dealing with registrations go directly to the owner from the owner's perspective.
Right.
This provision is under Title 21, so it holds the operator of the vehicle accountable. And I think it's fair to say that someone says, "Oh, I'm not used to this car. I didn't realize I was doing 85 miles per hour. It's a touchy accelerator." They're responsible for the operation and the safety of that vehicle. And I think that's a fair question.
Well, there's a disconnect then, right? Sorry to cut you off, but there's a disconnect because if this is in the operator section, we're actually talking about something that probably happened by the owner, not the operator. And so I think that disconnect thing makes the intentionality problem even more severe, right? Because if you're holding me as responsible as an operator and there's an intentionality component, how are you ever going to prove that for the operator if it's almost always going to be the owner that placed the protector on there?
Absolutely. If the owner and the operator are two different people, then there's no way to prove the intent of the driver.
Right. Okay.
Mr. Chairman, can I make another point?
Yeah, please do. Please do, Patrick.
Is that this prohibition in Title 21 does not prohibit a person from operating the vehicle with the obscured plate. It prohibits them from intentionally obscuring or modifying the plate.
Right.
That's a big distinction.
Yes, sir.
Right. Okay. Great. Delegate Terrazzo.
So just going back to our last bill discussion about in rem, like, is this not something I understand taking out the intent. I actually highly support that. But is it something that could be against the vehicle in the same way, like the same way as red light cameras?
Patrick, do you want to take that?
I don't know if the rationale is the same. I mean, the point of the registration is that we're trying to get people into compliance with important laws.
Registration?
Yeah, register your vehicle here if you live here. Whereas here, this is a rule of the road sort of situation.
Oh, sorry. Can we just talk about, I'm sorry, I may have confused the conversation. What about the same way that we write the ticket goes to the vehicle for a red light camera?
Well, do we want to be towing everybody? I mean, we could always write the ticket to the vehicle.
I think the problem is when you stop someone, you stop whoever the driver is, whether they're and if the owner is not present,
Okay.
then there's no way of holding the owner accountable at the time.
Thank you. Yeah. Thank
Yeah.
you.
That's helpful.
That is helpful.
Delegate Healy.
Yeah, just again, thinking about how, people can also just take the license plate off. They drive with stolen licenses. They do all kinds of things with the license plates. And you don't know what it is until somebody stops them. And I guess that's what courts are for, to sort all that out, right?
Chief, do you want to talk a little bit about how this compares to someone who just didn't have a plate on their car?
Yeah, so I think a couple things. One, Delegate, we see this a lot on motorcycles where they've bent the tag under, or they've removed the tag in its entirety. That's a whole nother challenge that we have. But likewise, you may see particularly vehicles with the tinted windows where they won't have the tag properly displayed on the rear. It will be displayed in the back window of a pickup truck or the back window of the car, which further obscures it and sometimes makes it very difficult. I'll be honest, I've stopped vehicles thinking that they didn't have any tags on it, only to get close enough and see that the tag is in the back window and obscured by the tint. So does that answer your question, Delegate?
I just kind of asking questions because I'm trying to figure out how this piece of the law fits together with the other pieces of the law about license plates. And, it seems like if we could streamline it and have something that, if it fits into a category that already exists, we might be able to fold it into that. But if not, we could go ahead with what's before us. That's all.
Okay. All right. Well, I think we're going to take this up. I mean, I guess I'll just ask, does anyone have any burning thoughts on either prohibiting the sale or making some kind of unfair and deceptive trade practice to lie to consumers about this? Does anyone have any burning thoughts about whether they do or don't like those ideas?
Can we
I like
add
it.
that? I like it. Yeah.
I like it too.
Mr. Chair, can Maddie, can you scroll down a little bit? I just wanted to point something out to you. It's not on point to what you're saying, but the Title 13 provision, if you'll notice, does prohibit the sale.
In 411.1.
Oh yeah, it's 411.1. Thank you. Yeah, go down a little bit more, Maddie. It's the next section. Thank you, Chief. A little bit more to the next page. Or is that the last
page I think we've got?
Oh, you didn't get it. Okay, the chief is right though. It's 13-411, and it prohibits the sale of registration plate covers or the advertisement of it. I just wanted you to know that.
Okay.
And also I wanted to ask the chief if he ever said he hasn't written any citations under Title 21. Do you know of, on anyone in your force or you yourself written citations under Title 13?
Not that I'm aware of, and it's primarily because of the moving violation that has the intent. It almost seems like there's a conflict. So the idea is someone goes in and says, well, under this, it requires me to prove intent, or requires intent. I didn't intend to do it. So I think to Delegate Healy's point, there's some ambiguity between the two. If that makes
sense. They tie in and it ties your hands.
Right. Yes, sir.
Great. Thank you for pointing that out about the registration plate covers. Maybe that speaks to the importance of trying to create some civil liability for these people too, because I'm not sure how difficult it is or how easy it is to prosecute someone from selling it if they're doing it on Amazon. And I'm not sure a prosecutor would necessarily want to take that on. But if we armed a citizen who purchased one of these to sue them, maybe that could be an avenue to spook them out of trying to sell into Maryland. But we'll discuss that more and we'll bring it back. And I'm Jen, Delegate Terrazzo, you have anything else?
I was just going to say maybe that's a different bill.
Yeah, it could be. It could be.
I really like what we're doing here.
Yeah.
So.
Okay. All right. So we'll take that back and we'll come to the committee with some ideas next week. Really appreciate that discussion. Chief Morris, thank you so much for joining us. That was very enlightening, and I didn't even know that about the whole warning, the e-ticks warning system. I didn't even know, so that was educational for me as well.
Certainly helps from an enforcement perspective, and equally to your point, I think this is an education piece for the consumer. Folks buy things that they don't realize they're not supposed to have.
Right.
When it comes to their vehicles, and education is equal, if not more important than the enforcement, because if we can educate, then we can minimize our enforcement necessities.
Right.
So.
Yeah, exactly. Okay. All right. Well, thank you again. We're going to move on to our last bill of the day. This is a repeat from last year, but we haven't taken it up this year yet. This is Delegate Kerr's HB 780. This allows SHA to decrease the maximum speed limit on an urban state highway by 5 miles per hour without an engineering or traffic investigation. We did pass this last year. I believe it passed the House with something like 110 votes. The idea here is that SHA doesn't need to go through the rigmarole of doing a traffic investigation to know that they need to reduce the speed limit by 5 miles per hour. I know that then Chairman Love worked a lot on this bill to make it workable and to make sure that it was clean, that they couldn't just do like a million repeat 5 miles per hour. Now, Patrick did watch the Senate hearing of this in JPR, and a couple of issues came up. And we've drafted amendments to try to correct them, because obviously anytime we can address things that we think are going to hold bills up in JPR, we want to do that now so that we don't have a million JPR deaths in March and April like we normally do. So 2 issues came up in JPR. One is whether or not people would be provided enough notice around the speed limit going down, and maybe they don't see the sign or whatever, and then all of a sudden they're violating the law. The other and the more serious concern that was raised in JPR was the idea that speed cameras would go in conjunction with a 5 mile speed limit decrease as basically a revenue generating scheme, where you trick people and you throw the 5 miles per hour and then immediately follow with a speed camera. And then all of a sudden people are not used to the 5 mile per hour difference. And now we've got a bunch of new speed cameras. So if you can see here on page 3, we have drafted some subcommittee amendments here to address both of these JPR points in hopes of smoothing the passage of this bill in both chambers this year. So if you can see here in 2.1, it requires SHA to provide notice of a decrease in the speed on its website and in a newspaper of general circulation. So Delegate Foley, our newspaper enthusiast, will love that provision. And 2.2 says that SHA may not use or allow the use of the speed monitoring system to enforce speed limits on any portion of an urban highway under its jurisdictions for which the speed limit has been decreased without performing an engineering traffic investigation for 6 months after the speed limit decrease. So we give people 6 months of the new speed limit before any traffic monitoring system can go in. So we're hoping that that placates all of our buddies in JPR and gives us a better chance with this bill this year. Delegate Healy.
Yeah, just on the notice thing, I think it might also be helpful, because this actually happened in my district, and it took it took like 3 years for us to get the speed limit dropped, and it was inappropriately fast to begin with.
Yeah.
And but if they post, when they change the speed limit, they should also post very prominent signage that this is a new change. Like they say, the traffic patterns are changed. They can put something up that says speed limit, new speed limit, or something like that, where people will have right there at that moment for maybe those 6 months.
Yeah. Could Matt Michler, could you hop on here and tell us, I have definitely seen that kind of signage before, about when, I think on a major state highway actually near my home, Norbeck Road in Rockville, there was a speed limit reduction recently, and there was some new signage. Can you talk about what the existing practice is for MDOT?
Yes. Actually, unfortunately, I don't have the exact answer there, Mr. Chairman. But I have seen those signs used previously. So I know it's definitely a part of the process, something that can be done.
Yeah.
With this language here, though, we were hoping at least to make sure there's something provided to the community in advance, some notice,
Right.
Broadly, that the speed limit will be dropping, or at least clarity around that.
Okay. Well, I think what I would recommend, rather than holding the bill up on this issue, is, Matt, maybe if you can go back and look at that before our full committee voting session, we can do another sort of maneuver here, whereas if there's an opportunity to mandate that kind of signage without ballooning the fiscal note and getting us in trouble with the appropriations committee, maybe that's something that you and I could talk about before tomorrow.
Yes, I could do that. I mean, I will note that if there is an additional requirement around signage, there is a cost to doing.
Yes, I understand that. Yes, absolutely. Okay.
Certainly.
All right, great. Any other discussion on the amendments?
Mr. Chair?
Yep.
Can I just raise one issue, because we did talk about, and MDOT was talking about it too, that in the current language of the bill at the top, page 3 of 3, the concern that you could decrease by 5 and then 5 more next year. But I don't think that's an issue with the language of this bill, because it says 5 miles an hour, the maximum speed authorized under 21801.1 B2 and 3. Now,
That's
that's
right.
shown in the bill. That's on page 2. And those are set numbers, 30 and
That's right.
35. So you can, under this language, you can only move it down 5.
Yeah,
And that's it.
exactly. That's a very helpful clarification. I know that was an issue that came up in last year's hearing a lot. And so I think it actually came up during the floor debate on this. So I appreciate that clarification. All right. Any other discussion? Any
Move the
motion?
amendments.
All right. There's motion on the
Second.
amendments. It's been seconded. All in favor of the amendments. Any discussion on the amendments? Seeing none. All raise your hand if you're in favor of the amendments. Anyone against the amendment? All right. On the bill.
Move
the
approval. Oh,
right.
second.
All right. Moved and seconded. Any last discussion or words of wisdom on the bill as amended? Seeing none. All those in favor of House Bill 780 as amended, please raise your hand. Any opposed? All right. We got one
You.
opposed.
Yeah.
That bill will also receive a favorable recommendation from the subcommittee. Great work, everyone, tonight, guys. Really appreciate everyone's thoughtfulness. As always, we had some good discussions. I will see everyone later today or in the morning.
All right. Good night.
Thank you.